Justice Jackson?
So your broadest theory, the one that you just articulated, does really seem to be motivated by the idea that the candidates are the object in the way that Justice Kavanaugh explored with you. And I guess I wonder if the response or the reply to that is really, when you're talking about an election, it's not the candidates who are the object, it is the voters. That really what an election is the opportunity for the people to decide who are going to govern them. And so in that context, one could argue that the voters would be able to make the same kind of grievance that you say is particular to the candidate here, right? You say your grievance is that unlawful ballots are being filed in this election. And I wonder why that's particularized to the candidate when, on my theory, the election is really about the voters, and voters could make that same argument, and why shouldn't they be able to? And if they could, haven't we undermined your idea that this is particularized to candidates in the way that you're articulating?
So what I would say is there are already, under your current doctrine, lots of ways for voters to sue. And I don't actually know if Illinois decides we're going to reverse this and we're going to close all the polls early and we're going to get rid of mail-in voting. I think any voter who comes in with a declaration and says, I want to vote by mail, I voted for mail.
That's a different hypothetical. What I'd like to do is focus on your standing argument, which we've said you have to have a particularized grievance, not a generalized grievance. And so my question is, why isn't unlawful ballots are being counted in this election a generalized grievance?
Well, here, can I try to answer it this way, which is to say, just because a lot of people share a concern doesn't mean somebody who is specifically gored by that concern is raising a generalized grievance,
But isn't the function of identifying who is specifically gored the harm requirement? Isn't the function of making a candidate say, with all of these extra unlawful ballots counted, I'm at risk of losing? That's what gives him the particular harm that then I would argue would entitle him to bring a suit, as opposed to the generalized grievance of there's an unlawful thing happening with respect to this activity. I mean, that's why it makes sense. Your second theory, to me, makes perfect sense. I'm not saying he wins, I'm not looking at the record, I'm just saying in terms of a theory of why a candidate could say I'm harmed, it's like the sort of Clapper idea that there's a risk of injury to me in a real way, and I'm showing you where that is. To me, that doesn't exist in the first theory, in the world where you're just saying there's an unlawful conduct going on. That does not identify or particularize him. Can I direct you to the third theory, the pocketbook theory? In a context, assuming that the injury of a potential election defeat, which I see as a real injury, assuming that's not imminent, I don't understand why additional polling costs isn't a self-inflicted harm. So if you take Justice Sotomayor's example, where you have a candidate who has a 98% chance of winning, based on everything we know, based on all the polls, whatever else, if he decides that he's going to spend money for the 2 extra weeks of counting, I don't understand why that's not on him. There's really no risk of harm to him to have that counting happen, and we've talked about self-inflicted injuries in Clapper, for example, as not being sufficient.
So I'd like to just briefly talk about the first point and then get to the third theory. Just on the first point, I still say, harm, injury, yes, we think we've identified a specific injury that visits on the candidate specifically. The fact that everybody cares about the votes being accurate, I mean, I'd like to think everybody cares about the environment, but we let the person who's directly downstream from the pollution, we say they're the ones that have standing to bring the suit, even though everybody might care, everybody might be offended at some level by the pollution that's in violation of the law. It's the same here. Everybody would like the elections to be conducted lawfully and in compliance with federal law, including the voters, but the injury is visited more specifically on the candidate. They're the ones
even though the voter says my vote is diluted by all of these other unlawful votes, right? Don't they have the same kind of injury you're talking about by the extra votes that come in?
I mean, ironically, the petitioners here tried to make a voting standing argument below as well. and that was rejected. And
Right.
we
and
didn't.
So similarly, shouldn't this one be rejected on that same basis?
No. And what I would say is the candidate's different. His or her name's on the ballot, right there. That just tells you there's something just obviously different about it. But then the other thing is, I think the reason that in a case like Lance, you're worried about voter standing is because there are almost as many voters as taxpayers.
Can you speak to the pocketbook injury?
Yes, I'd be delighted to. So on the pocketbook injury, I do think it is a mistake to think that, and this is really, Judge Scudder's dissent handled this issue quite well, I think, and I think it really gets down to the issue of, is this like Clapper? And when the injury itself isn't speculative, but the government is going to do something, and it is going to happen, late arriving ballots will be counted. At that point, the only remaining question is the expenditure of resources reasonable?
Yes, but the harm in Clapper wasn't imminent because the rule wouldn't necessarily apply. Here, the harm isn't imminent because even though the rule will apply, he may not lose as a result. There's still not a risk of him losing even though this rule applies to him. They're indistinguishable in that way.
With respect, I think the reason the injury was so speculative in Clapper is because the rule would never apply to the petitioners, the U.S. citizens. It was a moral certainty it wasn't going to apply directly to them. And then it was entirely speculative as to whether it would implicate their foreign clients at all. Here, what is prompting us to spend money is going to happen. Illinois will count late arriving ballots.
But if you're a 98% candidate, what difference does that make? I mean, it only harms you if you could lose as a result of the new ballots being counted, right?
So with respect, as a practical matter, the 98% candidate's not going to bring the case, but the 70% candidate, the 60% candidate, the 56% candidate, or even the 43% candidate might bring the case. And those margins of difference make a difference, and the whole election system operates on the premise that we care about more than the binary final outcome.
Thank you.
Thank you, Counsel.